morning, Your Honour. Case number IT 9510A. The prosecutor versus Goran Jelisić.
Yes, I think the problem may well have been from my side. Mr. Jelisić, I turn to you again and ask whether you can hear me.
Čujem, časni sude.
May we have the appearances?
May it please Your Honours, I'm Upuan Siapa, appearing for the prosecution. Mr. David Jelisić is the case manager today. Thank you, Your Honours.
Or Mr. Jelisić?
William Clegg, representing Goran Jelisić.
Good. The appeals chamber of this international tribunal meets today pursuant to a scheduling order issued by this chamber on 28 June 2001, appointing today as a day for delivery of the judgment in the case of prosecutor against Goran Jelisić. The appeals chamber will now deliver judgment. Copies of the judgment, which is in writing, will be made available by the registrar to the parties towards the end of this hearing. I shall not be reading out the text of the judgment except for the operative paragraph. Following the practice of this tribunal, I shall limit myself to a summary of it. The summary does not reproduce all the elements of the written judgment. I emphasize that the only authoritative account of the appeals chamber's conclusions and its reasons for those conclusions are to be found in the written judgment. This chamber is seized of two appeals, one filed by the prosecution, one filed by Mr. Goran Jelisić. They arise in this way. Mr. Jelisić was indicted for crimes of genocide, violations of the laws or customs of war, and crimes against humanity committed in May 1992 in the municipality of Bičko in the northeastern part of Bosnia and Herzegovina. At the trial stage, an agreement of the factual basis was reached between the parties. On 29 October 1998, Mr. Jelisić pleaded guilty to 31 counts, comprising violations of the laws or customs of war and crimes against humanity. He pleaded not guilty to the genocide count. The subsequent proceedings before the trial chamber were therefore limited to the genocide count. The trial commenced on 30 November 1998, and the prosecution completed its presentation of evidence on 22 September 1999. At that stage, the trial chamber informed the parties that it would render a judgment pursuant to Rule 98 bis B of the rules. This rule provides as follows. The trial chamber shall order the entry of judgment of acquittal on motion of an accused or proprio motu if it finds that the evidence is insufficient to sustain a conviction on that or those charges. The prosecution filed a motion to postpone the trial chamber's decision until the prosecution had been given the opportunity to present arguments. On 19 October 1999, the trial chamber pronounced its oral judgment. Written reasons, together with sentencing, followed on 14 December 1999. It decided that there was an indissociable link between the prosecution's motion to be heard and the judgment itself, and dismissed the motion. It convicted Mr. Jelisić of the counts alleging violations of the laws or customs of war and crimes against humanity, to which he had pleaded guilty. A single sentence of 40 years imprisonment was imposed. It acquitted him on the count of genocide pursuant to Rule 98 bis of the rules. Both sides appealed. The prosecution against acquittal on the genocide count, Mr. Jelisić against sentence on the counts on which he pleaded guilty, together with a challenge to cumulative convictions, therefore, as mentioned below. The prosecution's appeal raises three grounds. The first ground is as follows. The trial chamber made an error of law by not giving the prosecution an opportunity to be heard on a proprio motu decision of the trial chamber under Rule 98 bis B of the rules. The trial chamber erred in law by adopting the standard of guilt beyond a reasonable doubt for the purposes of a Rule 98 bis B determination of the sufficiency of the evidence to sustain a conviction. 3. The prosecution's third ground has two parts. First, the trial chamber erred in law in holding that the requisite mental state for genocide in Article 4 of the statute includes the dolo specialis standard and not the broader notion of general intent. Secondly, the trial chamber erred in law and in fact in deciding that the evidence did not establish beyond all reasonable doubt that there existed a plan to destroy the Muslim group in Britschko or elsewhere within which the murders committed by Mr. Jelisić would allegedly fit. And the trial chamber erred in law and fact when it decided that the acts of Mr. Jelisić were not the physical expression of an affirmed resolve to destroy in whole or in part a group as such, but rather were arbitrary acts of killing resulting from a disturbed personality. The prosecution requested that the case be remitted to differently constituted trial chamber for a new trial. The cross-appellant Mr. Jelisić has raised the following grounds in his appeal. 1. The trial chamber erred by imposing cumulative convictions. And 2. the trial chamber erred in fact and in the exercise of its discretion when imposing sentence. Under the second ground of appeal, the cross-appellant's arguments included the following. The sentence passed by the trial chamber for the counts in respect of which he pleaded guilty erroneously took into account prosecution evidence given at his trial for genocide. The trial chamber made an unauthorized double conviction on counts 16 and 17 concerning the deaths of two brothers, while the indictment alleged one killing. The absence of a recognized tariff for sentencing, then the trial chamber failed to accept the remorse shown by the cross-appellant as genuine. Then the trial chamber failed to consider that the cross-appellant was not a commander. Then the trial chamber failed adequately to consider the role of the cross-appellant in the broader context of the conflict in the former Yugoslavia. Then the trial chamber was obliged but did not consider the general practice regarding prison sentences in all the courts of the former Yugoslavia. Then the trial chamber failed to give him any credit for his guilty plea. Then the trial chamber failed to consider his cooperation with the prosecution. And lastly, the trial chamber failed to give adequate consideration to his youth. The cross-appellant requested that his sentence be reduced. With regard to cumulative convictions, he asked that his convictions for what he contended was a lesser crime be quashed. I will now briefly go through the findings of the appeals chamber. I shall first deal with the prosecution's appeal. As to the first ground of appeal, the appeals chamber finds that the prosecution has a right to be heard on the question of whether the evidence was sufficient to sustain a conviction. The fact that the trial chamber had a right to decide proprio motu pursuant to Rule 98 bis B does not relieve it of the normal duty of a judicial body to first hear a party whose rights can be affected by the decision to be made. As to the second ground of the prosecution's appeal, the appeals chamber holds that the trial chamber erred in applying the test for determining whether the prosecution evidence is insufficient to sustain a conviction. The correct test is whether there is evidence, if accepted, upon which a reasonable tribunal of fact could be satisfied beyond reasonable doubt of the guilt of the accused on the particular charge in question. As to the first part of the prosecution's third ground of appeal, the appeals chamber finds that the requisite intent is one to destroy in whole or in part a national, ethnical, racial, or religious group by one of the prohibited acts enumerated in Article 4 of the statute. It considers that the trial chamber was referring to this intent when it spoke of dolus specialis. The appeals chamber further holds that the existence of a plan or policy is not a legal ingredient of the crime of genocide, although it may be evidentially of assistance. As to the second part of the prosecution's third ground of appeal, The appeals chamber is of the opinion that the trial chamber's erroneous application of the standard under Rule 98 bis B led to an incorrect assessment of the evidence. However, in the circumstances of this case, the appeals chamber does not consider it appropriate to reverse the acquittal and to remit the case for further proceedings. As to the cross-appellant's first ground of appeal, the appeals chamber finds that cumulative convictions under both Articles 3 and 5 are permissible. The appeals chamber now comes to the cross-appellant's second ground of appeal. As to counts 16 and 17 of the indictment, the cross-appellant pleaded guilty to the killing of only one of the brothers, Huso and Ismail Zahirovic. The trial chamber erred in finding him guilty of murdering both of them. However, as the appellant was convicted of 12 murders, in the opinion of the appeals chamber, the erroneous conviction does not affect sentencing. With regard to the cross-appellant's submission that the trial chamber erred in the exercise of its discretion when imposing sentence, as has been noted, several subgrounds were raised. The appeals chamber's findings with regard to each subground will not be addressed here. However, the appeals chamber found that Rule 101A of the rules provides that a convicted person may be sentenced to imprisonment for a term up to and including the remainder of the convicted person's life. Thus, the trial chamber has the discretion to impose life imprisonment. The trial chamber also has a broad discretion as to what factors it may consider in sentencing and the weight to attribute to them. Generally, the appeals chamber found that the cross-appellant has failed to show an error in the exercise of the trial chamber's discretion. I shall now read the paragraph from the written judgment setting out the disposition, and at this stage I will invite Mr. Jelisić to stand. The disposition runs as follows. 1. The appeals chamber unanimously allows the prosecution's first ground of appeal. 2. The appeals chamber by majority, Judge Pokar dissenting, allows the prosecution's second ground of appeal. 3. In respect of the prosecution's third ground of appeal, 1. The appeals chamber unanimously dismisses the prosecution's appeal with regard to the alleged error of law by the trial chamber in its application of the term dolus specialis. 2. The appeals chamber by majority, Judge Pokar dissenting, allows all other aspects of the prosecution's third ground of appeal. 4. However, the appeals chamber by majority, Judge Aberdeen and Judge Wald dissenting, considers that in the circumstances of this case, it is not appropriate to order that the case be remitted for further proceedings and declines to reverse the acquittal. 5. The appeals chamber unanimously dismisses the cross-appellant's first ground of appeal. 6. In respect of the cross-appellant's second ground of appeal, 1. The appeals chamber unanimously finds that the trial chamber erred in finding the cross-appellant guilty of 2 murders under counts 16 and 17 of the second amended indictment, when he in fact pleaded guilty to only 1 of the murders. 2. The appeals chamber unanimously dismisses the other aspects of the cross-appellant's second ground of appeal. 7. The appeals chamber unanimously affirms the sentence of 40 years of imprisonment as imposed by the trial chamber. 8. In accordance with Rule 1037 of the rules, the cross-appellant is to remain in the custody of the International Tribunal pending the finalization of arrangements for his transfer to the state where his sentence will be served. Done in both English and French, the English text being authoritative. Then there follow the signatures of the 5 members of the bench, myself, Judge Flora, Judge Nieto Navier, Judge Wald, and Judge Pokar. Dated this 5th day of July 2001 at The Hague, the Netherlands. Judge Nieto Navier appends a separate opinion to this judgment. Judge Shahabadin, Judge Wald, and Judge Pokar append partial dissenting opinions to this judgment. Mr. Jelisić, you may sit. Madam Registrar, you may now hand out the written judgments. There ends the proceedings, unless colleagues have something to say. The court will now accordingly rise.
All rise for the oath of